On the last night of her life, Joanne Samak set an alarm on her phone and hung a red dress on the wardrobe door. The next morning was the first day of her own business. She had spent months building towards it. She was 49 years old, and she died in her home in Droitwich Spa in the early hours of the 1st of July, 2024. Her husband told police she had done it to herself. And for a while, the medical evidence could not prove him wrong. Joanne Samak was an interior designer. She had trained in it, worked in it, and in the months before she died, she had been laying the groundwork to go out on her own. Clients, finances, the unglamorous work of building something from nothing. She was the main earner in her household. That was said in court, plainly, as a fact about how the family worked. Her brother, Mark Vale, spoke for the family after the verdict. He called her loyal, kind, and caring. Deeply loved, he said, not only by her family, but by her many, many friends. Most importantly, he said, she was an amazing mom. The family's statement described a woman who was generous, creative, and full of fun, with a wonderful sense of style. It listed what she cared about: interior design, fashion, art, nature. It said she had a zest for life that was infectious. It ended by saying she had so much more life to live. Starting a business on your own is not a thing that happens to a person. It is a thing a person does over months, in the evenings and at weekends, while still holding down the job that pays for it. Clients have to be found. Money has to be arranged. Decisions get made about what the thing will be called, and what it will look like, and who it is for. By the end of June 2024, all of that was done. The groundwork was laid. Monday, the 1st of July, was the first day. That is the woman who set an alarm on the 30th of June. The alarm and the dress are not sentimental details. They became evidence, and they became evidence because of what her husband would later say about her state of mind. A person does not choose tomorrow's clothes if they do not expect to be there to wear them. Joanne met Mohamed Samak in 2011 in Egypt. He was working in entertainment at a hotel in Taba. She was traveling. They married in March 2014, and at the end of that year he moved to England permanently. Before that, he had been an international athlete. He played hockey for Egypt, and afterwards moved into coaching, working at one point with the Wales under-18 squad. It was a career with a certain standing inside the sport. In England, that career did not continue. He coached in short spells and struggled to find permanent work. Joanne earned. He did not, consistently. The court heard that this put strain on the marriage. By 2024, they were sleeping in separate bedrooms in the same house. There were other things happening that Joanne does not appear to have known about. He was under financial pressure serious enough that he had sought help from advisors. The prosecution told the jury he had kept an eye on his position as a named beneficiary of her life insurance and her pension, and his phone showed he had been in contact with another woman in the weeks before Joanne died messages, and meeting her. Taken separately, none of those things means very much. Plenty of marriages carry financial strain. Plenty of people are named on a spouse's policy without ever thinking about it. Contact with another person is a reason to leave a marriage, not to end a life. The prosecution's case was not that any one of them was a motive. It was that all of them were true at the same time, in the same house, in the same week that Joanne was building something of her own that did not depend on him. None of that was visible from outside. To anyone looking in, there was a married couple in a quiet cul-de-sac in Worcestershire. What is not in this case, and it matters, is any earlier report. There is no record of police being called to that address before. No previous complaint, no history on file. Whatever was happening in that marriage, it had never been written down anywhere. At around 3:10 on the morning of the 1st of July, a neighbor heard a woman screaming. The medical evidence at trial placed Joanne's death shortly after that, somewhere between 3:30 and 4:20. Mohamed Samak called 999 at 9 minutes past 4. That is 59 minutes after the screaming. It is roughly half an hour after she is likely to have died. It is worth being concrete about what an hour is, because the word does a lot of work in this case, and it is easy to let it slide past. An hour is long enough to make a decision, change your mind, and make it again. It is long enough to go upstairs and come back down. It is long enough that the ambulance, which would eventually be called, could have arrived twice and still had time. His explanation for the delay was shock and confusion. That is not an unreasonable thing to claim. People do freeze. But the prosecution was able to show what he had actually done with some of that time, and it was not freezing. On the call, he said his wife had a knife in her stomach. He said he had found her bent over on her bed. He gave the impression that this had just happened, minutes before. When paramedics talked him through CPR, he attempted it. He later admitted in court that he had not done it properly, that he had not pressed hard enough, and that he had avoided some areas because he did not want to touch her blood. Joanne had been stabbed 6 times. The wound that killed her went through her breastbone and into her heart. His account did not stay still. The first version was the one he gave on the phone and to the officers who arrived. He had woken at about 10 past 4 to use the toilet. He found her then. Then police told him a neighbor had reported screaming at around 3. The second version arrived the next day, in interview. Now he had woken earlier to a noise from the bathroom. Now he had seen Joanne on the landing, holding a knife. She had told him to leave her alone. She had said she did not need help. She had gone into her bedroom, and he had watched her stab herself. By the time he gave evidence at trial, the account had one more detail in it. He had watched her take her final 2 breaths. He also told police something about her. He said he had been worried about her mental health. He said she had been stressed about losing her job, and that he was worried about how much she drank. Joanne's friends and family said they had no such concerns. They said she was not struggling. They said she had things to look forward to. One of those 2 accounts came from people who had known her for years. The other came from the only other person in the house. The prosecution's argument about the shifting account was precise. They did not say he was a poor witness or that his memory was unreliable. They said the account moved each time the evidence moved, and always in the direction the evidence required. He said he found her at 10 past 4 until he learned that a neighbor had heard screaming at 10 past 3. Then he had been awake earlier after all. He said she stabbed herself, and by the time he was in the witness box, he had watched her final 2 breaths. Memories do not usually improve in that particular way. They do not usually acquire exactly the detail that the last problem needed. There is one more thing he did during that hour. He moved her body, and in doing so got her blood on his clothes. He took the clothes off, put them in a bag, and put the bag in the loft. He explained this to police. He said he was frightened of being blamed because he was the only adult in the house. He hid the clothes before he called for an ambulance. That sequence is the whole case in miniature. Whatever else was going on in that hour, one of the things he did with it was think about how this would look, and note the order. Not call for help, then worry about the clothes. The clothes came first. Police also found no searches on any device that night of the kind a person makes when someone in their house is dying. Nothing looked up. No messages to anyone. His phone was in the room with him. That absence is easy to miss and hard to explain. A man who has genuinely just watched his wife kill herself and has frozen for an hour leaves some trace of that hour. There was none. The evidence that people expect to settle a case like this is the medical evidence. In this case, it did not. The forensic pathologist was Dr. Alexander Kolar. He gave evidence at Worcester Crown Court on the 8th of October 2025, and what he said was more complicated than either side would have liked. Joanne had 6 wounds. 5 were to the front of her body. 1 was to her side or back. The largest was the one to the chest, through the breastbone into the heart, and that was the one that killed her. There were bruises on her arm, some accidental bruising to her shins and ankles, and a blunt force injury. There were no defense wounds, no cuts or scrapes to the backs of her hands or her arms, the injuries a person gets when they try to stop a blade. And the 5 wounds to the front were arranged, more or less, in a straight line down her body. Dr. Kolar told the court that wounds inflicted by another person tend to be more haphazard. The uniform arrangement of Joanne's injuries, combined with the absence of any defense wounds, meant that self-infliction was a possibility. He said the idea that the wounds were self-inflicted could not be ruled out. He also said a third party could have been involved if she had been restrained or unconscious at the time. Asked for a conclusion, he said the wounds could have been self-inflicted, or they could have been inflicted by someone else. There was, he said, no concrete conclusion. That is not a pathologist failing. It is a pathologist declining to say more than the body could support. But it meant the single piece of evidence a jury would most want to lean on could not carry them anywhere. Most true crime accounts of a case like this one will tell you that multiple stab wounds are impossible to inflict on yourself, that the depth and the angles rule it out. In this case, a Home Office pathologist stood in a witness box and said the opposite, that the pattern was uniform, that there were no defense wounds, and that self-infliction could not be excluded. That is why this case took 2 trials, not because the prosecution was weak, but because the strongest single category of evidence in it pointed nowhere. The first trial ran for 4 weeks. The jury was discharged, unable to reach a verdict. That is worth sitting with, because it is usually skipped. 12 people heard the hour, the loft, the changing account, the alarm and the dress, and the pathologist saying he could not rule out either possibility, and they could not agree. A hung jury is not a technicality, and it is not a failure. It is 12 people telling a court, honestly, that the evidence did not take them all to the same place. Somewhere in that room, at least one person could not get past what Dr. Kolar had said. The Crown Prosecution Service decided to try again. The retrial ran for 5 weeks. On the 29th of October 2025, at Worcester Crown Court, the jury returned a unanimous verdict. Mohamed Samak was guilty of murder. He sobbed as it was read. 2 days later, Judge James Burbage K.C. sentenced him to life imprisonment with a minimum term of 21 years, less the 483 days he had already served. The judge said his actions were wicked beyond comprehension. He said Joanne had no chance to defend herself. He addressed the defense argument directly. Counsel had said that if there was an intention to kill, it had been momentary, formed, and regretted in seconds, and the judge accepted the premise while rejecting what was built on it. Even a momentary intention, he said, was an intention to kill. He went further. If it had truly been a brief impulse and immediately regretted, there was something Samak could have done about it. He could have called for help. Instead, the knife stayed where it was, and more than an hour passed. The account Samak had given, the judge said, was a wicked story, and he could not be found remorseful because he still would not accept what he had done. Here is what tends to get lost in this case. The forensic evidence did not convict Mohamed Samak. It could not. Dr. Kolar told the court, honestly, that the wounds were compatible with either explanation. What convicted him was ordinary life. An alarm set for 7 in the morning. A dress hung on a wardrobe door. A business she had spent months preparing to open, with clients lined up and money arranged. A woman making plans on a Sunday night for a Monday she fully expected to see. Set that against what he told police that she had been drinking, that she was worried about work, that her mental health had been deteriorating, and the two do not fit in the same room. And that account only appeared after she died. It came from the one person who needed the jury to believe it, about a woman who could no longer be asked. That is a specific kind of harm, and it does not end with the killing. It asks everyone who loved her to sit in a courtroom and argue about her state of mind twice. In this case, across 9 weeks of evidence and 18 months of hearings, defending a version of her they should never have had to defend at all. The Crown Prosecution Service named it in their statement afterwards. They called the attempt to present the crime as a suicide callous and said it had caused further anguish to her family. There is a wider point buried in that. When a defense in a case like this one is that the victim took her own life, the burden of answering it falls in an unusual place, not on experts. Dr. Kolar had already said the body could not settle it. It falls on the people who knew her friends, her family, her brother, who have to stand up and testify about her state of mind in the middle of the worst period of their own lives, because the alternative is letting the account stand. Joanne's family did that. They did it twice. Her family, meanwhile, said what they had always said, that she was loyal, kind, and caring, that she was an amazing mum, that she had so much more life to live. She had set an alarm for 7 o'clock. She never heard it.